Welcome everyone to Kingdom Network. This is a program that discusses matters business, and we've been discussing with you, and we've been bringing very interesting speakers. And today we'll pick from where we left last time, discussing with a lawyer, Mr. Kariba Karaoke, on matters land. And we're going to focus on the area of buying land, selling land, and inheriting land. I'd like to encourage you this morning, please prepare your questions, send them to the numbers which are provided on the screen on the areas of buying land, selling land, and inheriting land. So we are going to look at those particular three areas for today, so restrict yourself to those areas. If you're watching us on Facebook, please like and share. If you're watching us on YouTube, please like, share, and subscribe. And immediate to my right is Mr. Kariba Karaoke. I'd like to welcome Kariba to this program this morning. You can introduce yourself to the viewer. Welcome.
Thank you, Mr. Thank you again for having us. Mr. Lekaya, I'm glad to be here once again to take this discussion.
Thank you. And on my immediate left is Enoch. Enoch, welcome.
Thank you so much, Doctor. My name is Enoch from House of Faith. I'm excited to be here today to learn about buying land, selling land, the entire framework of the transactions that entail. I'm really excited and to have our favorite counsel here, Mr. Karaoke. I've had the conversation with him. I'm happy he was in Uganda before. So there is so much to really learn and connect. When you look at the young people, one of the discussions they have had lately is how do I grow my finances? And one of the fundamental truths that that really count is investing right. The way to grow your finances is investing right. And it's been a challenge for very many to find the right way to invest. When you look at our programs here, I'm so glad that we've really delved deep into the entire domain of real estate investment, which is really informing the young people that it's a viable avenue, something that they can really trust their finances with. Now getting better to having a lawyer coming in to really weigh in on the legal part of it, the transactions, navigating the framework of doing the transactions is something that we didn't have, and I believe it is fitting the entire puzzle and giving us an assurance that we can really grow our finances. I'm really excited and I can't wait to learn more.
Wonderful.
Yes.
So how has it been the week for you?
The week is really exciting. Today at church we are having a mission that is going on. In fact, those of you who are passing through Thika Road, Roysambu there, TRM, we are having a crusade that is ongoing. We have young people that are really, winning souls. They are really doing so much, and this is all by the mentorship of our spiritual father, Bishop Peter Ndugu. So we are really excited, and it's a great week.
Thank you very much, Enoch. Yeah. Coming back to the lawyer in the house, my learned friend, I know that land is really a delicate issue in this country. Briefly, what are the key issues that people need to look at before we come to the process? What are the key issues that people need to look at? And we'll get into them in depth later.
You rightly put it, Dr. Land is a very emotive issue in Kenya. And one of the key issues that need a question that needs to be answered is the question of a validity of a transaction. For instance, how valid is a transaction? What are the circumstances that surround making a transaction valid or invalid? We talk about capacity to contract. Who has the capacity to sign a contract? And you see the Land Act 2012 also insists, and this has been in the land management framework for a long time, that all transactions in land must be in writing. So as we get into these conversations, we have to also bring ourselves to the reality of what is a contract for sale, what is a contract for purchase. When we're talking about inheritance, how does a will work, how does succession work? So these are questions that we might want to just enlighten our viewers on, as they also look out, as Enoch rightly put it, to investing their resources, because land is emotive, because land is expensive. And there's a lot of emotional attachment to a process of purchase of land, even from the sentimentality of these kinds of purchases and owning this kind of land. So I look forward to a very great conversation on these things, and also adding value to our viewers' understanding on issues of land and moving forward, how they should manage themselves in these kinds of transactions.
Wonderful.
Yeah.
So let's start with buying land. I'm someone who wants to buy land. What is the process from the buyer point of view? Then we'll come to the seller.
As a buyer of land, I think one of the things that we insist on as lawyers is the buyer must beware. And by being buyer must beware, it means that, especially like now it's flooding, it is important that you visit your land that you intend to purchase, so that you can also tell whether you're buying a small fishery area or you're buying something that can actually be a viable piece of.
So this is the best time.
This is the best time to actually go and view this high-end developments. Because as funny as it may seem, the recent occurrences are telling you that there are some buys that were good buys and there are some buys that were very bad buys. And in areas that are as upmarket as Runda, you find that some units are actually constructed around or along a riparian pathway. It might not necessarily be riparian land, but it could be a riparian pathway. And you see, the thing about nature, it's brutal. And as you have seen, it is important for you to ascertain what you're buying, and that ascertaining means you can be able to physically visit, peacefully visit, because it is one thing to visit physically, it's another thing to peacefully visit. You can be able to intentionally do your own ascertainment. So you are enabled, before you sign a contract, bring in your own surveyors. Let them go and check whether the subdivision was done correctly. Let them give you a map to tell you that this is the actual geolocation of the land, that the title you're buying is actually the physical land that you're purchasing. So what we do for our clients is we have these particular in-house survey processes, and I would encourage citizens to make those kinds of relationships, so that before you purchase, you can have someone go and ascertain the beacons. The beacons are principally the markings showing you that this is the boundaries and borders of this land, and that will help you to see the physical location and ascertain that the goods you're buying are actually, because land is also a commodity, so the goods that you're buying are actually as advertised. So the parcel number reflects on the map, that is the registry index map, of course depending on the type of land you're buying, and it is the boundaries as you have been told, and the measurements are accurate. So once you have verified that, then as a purchaser you have another obligation to, that is the first step of due diligence, even before you get into the question of searches, because if the map does not tally, then there is no point of getting into the next phase. So the next phase for you would be prudent for you to do a search. Now a land search, in recent jurisprudence in this country, it was found that just an ordinary search is not enough. You must be able to have conducted a historical search to an extent of finding out who are the previous owners and how did this land get to this point. Because then if there is an issue within the historical search, then the green card will give you, the green card is the historical search result. It will give you, it will either not come out, if there's an issue, you'll not be able to get a green card, or it will come out and highlight some form of discrepancy. So if that is the case, then you are obligated to stop that process at that point. So now, in an ideal situation, your survey search has yielded a positive outcome, and your search has yielded a positive outcome. That is where a contract will come in. Now, a contract is basically an agreement for sale. There exists no mandatory requirement for you to have a lawyer in concluding a contract for sale, but it is highly advised that you have an advocate present to also guide you on the terms of purchase, because the sale agreement will be drawn by the vendor. So whoever is selling will draw an agreement, and they will sell to you on their own terms and conditions. Now it is important for you to read through, especially when you talk about things like other pre-existing interests. Because for instance, let's say the land borders a school, and there is a mandatory requirement by the school that you cannot build maybe a hotel. So you might also find that the contract is restricting the fitness for purpose. Are there things like pre-existing land ownership agreements and covenants within that particular area? You want to purchase a piece of land to build a flat, but there's an existing agreement saying that this area is a low density population area. According to the community, we've agreed that this is as far as we can go as far as construction. So for you to be able to synthesize that kind of information, you might require to have legal support in that process of negotiating the contract. What are the terms of payment? Ideally, the Law Society conditions for sale dictate that we could issue a deposit and an undertaking to complete, so that at the very least you don't lose the whole amount of money that you're giving in, and also lose the land that you're trying to purchase. So what we would want to do is to give the vendor a deposit and an undertaking to pay him the balance, and then the vendor is now obligated to transfer the land into the purchaser's name. So once you get the purchase, then you go back to the original process of verification. So you verify that the boundaries are correct according to the sale agreement, it's the title that you purchased, and you verify that the title that you've been given is actually registered in the lands registrar in your name by way of another further search. So once you've confirmed that, then you give a notice of completion to tell them that we have verified that these documents are now in order, the maps are in order, the border and boundaries are in order, and then you can be able to now pay the balance to complete the purchase. The purchase price and now ideally completing the purchase of land. However, you cannot be able to transfer the land without an advocate. And this is why we usually, because Kenyans, again, we enjoy the quick, fast options of getting land and titles. So the idea is you cannot be able to transfer unless a transfer is witnessed and attested by a practicing advocate. So what you then want is to get a lawyer at that point to be able to support you in registration of the transfer. Now, to be able to register the transfer, the issue of tax liability comes in at this point, because there is something that we call stamp duty against the sale of land. There is something that we call capital gains tax against the purchase of land. So what would happen is the stamp duty and all other costs around the registration are the obligation of the purchaser. But the issues of consents, and we'll get to that, are the obligations of the seller and the obligations of the purchaser. Now, the seller is under an obligation, if the land is agricultural land, to give you what we call a land control board consent. For you to get land control board consent, the seller, if they are married, would have to get spousal consent to sell, because there are instances where a husband will sell matrimonial property and then a wife will contest that they did not give consent. And in accordance to the law, then that is what we call now a voidable contract. It's a contract that is legal, but it can be thrown out because of a technicality. So you need the seller to give you a spousal consent, and the seller, and in the absence of a spouse, the seller needs to swear an affidavit noting that they are not married and that property is not subject to any matrimonial cause, or there is no other overriding interest. And those are issues that can be discussed within the contract on the basis of what we call sale guarantees. So this person guarantees and warranties. So this person will warrant that this land is not subject to any other interest, and they give you a freehold or a leasehold clear title, clear of any other third-party interest. So the issue of consent is very important, because without, if it is agricultural land, without the land control board consent, you cannot transfer that land. Because the land control board consent, the land control board has to sit and determine that Enoch wants to sell his property. Is the consideration, is the payment that they are being receiving a fair payment? That's not their determination, but those are questions they usually ask within the form. And then they will also ask whether Enoch is married. Are there any other interests? Has he provided a certificate of consent from the wife? If the case is yes on that particular instance, whoever is purchasing, what is your intended use of this land? If they feel that the use will not agree, they will not conform to what they ordinarily would want, then they might decide it is within their right to refuse to issue that consent. In most cases, the board usually conforms to what the parties have agreed with, but it is prudent that that step is not skipped, that you can also have a record of your booking of that land control board consent, a receipt for the payment, and also the outcome of the consent. So you'll get a written form consent noting that the board sat at this time and they agreed that Enoch can sell his land to Daktari on this particular, and that is what you will attach as part of the completion documents when you're going to transfer the land. So when you're talking about a payment for stamp duty, depending on the type of the land, there is a percentage. For instance, for agricultural land it is 2%, and for commercial property it is 4%. So that percentage is payable by the purchaser, because all costs that attach to transferring then come back to the purchaser. Now, what you want to be keen on at this particular juncture is that the government has harmonized payments of systems and taxes around transactions in almost all registries. So you have to book that particular transaction on Arthisasa, which is the online platform that we are currently utilizing for earth and for land transactions, and then make all your payments through that platform. including your stamp duty payments to the Kenya Revenue Authority. So then you will be given a stamp duty receipt, and then you will now forward your transfer documentation for what we call franking. Franking is principally stamping of that transfer showing that the taxes have been paid, and now it's an instrument that is registered. And then you will issue the transfer. What you will need to take to the registry is a transfer form, the consent that you got, of course, both spousal and land control board. The transfer has to be executed by the parties and witnessed by practicing advocates who are licensed to actually practice for that particular period. Your stamp duty receipts that you will now show that you have paid the stamp duty for the transaction. And finally, the original title deed or document of title that you will have been given by the seller. Once you issue that, the government will now register the transfer at the lands registry and issue you with a new title deed now in your name. The obligation at this point is for you to verify, so that now when, in case anything was to ever come in future, then all those documents will also show that you're what we call an innocent purchaser for value. So you have complied with all the legal provisions, and you have the evidence and the trail from the sale agreement all the way to the final search showing that you have now effected a transfer of the title in your name. So for the purposes of a purchase, that is in a nutshell how the process would look like.
Wow, very elaborate, and thank you for that. Now let's come to the most common issues that a purchaser of land faces in Kenya. Which areas are people conned their money? Because we hear a lot of people being conned. For example, when you started, you talked about the verification of the actual vehicles and all that. I've had cases whereby people bought a piece of land, you are shown a piece here, but when you go and build there, later somebody shows up and you realize that actually your land was somewhere else, or might be even the next plot, because you didn't verify. We've had cases whereby actually people bought just air. There are some cases whereby people actually got the fake title deeds and might be even went to an extent of transferring somebody else's land or were caught in the process. Which are the most common issues that somebody buying land faces in this country and it should be aware of?
I think I'll fall on reliance on something that Steve Jobs says. Steve Jobs says that anything that you are putting yourself to that you don't understand, do not touch it. And understanding can be outsourced. So for processes of land, I highly encourage you to get a qualified conveyancing advocate. The same way we have orthopedic doctors, we have heart surgeons, we have neurosurgeons, we also have conveyancing and land transaction advocates who will be able to see these things based on their usability and how long they've been practicing in the space. So you want to put yourself in a conversation with someone who understands the process if you do not appreciate it yourself. So, excuse me. So where you will be caught up, for instance, and those are good examples that you've given, you will be caught on the aspect of ascertaining the parcel. So when you say ascertain, if you're being sold parcel A has a number, a land reference number. So that land reference number is 1121 Kiambu. When you see 1121 Kiambu, it means that this land is in Kiambu district, locality within Kiambu. So in most cases you will see Kiambu Dindigwa, 1120. Kiambu Runda, like that. So principally the land is ascertained in terms of location. So what you have is something called a registry index map. So that number that is on that title is attached to something we call a mutation. The assumption is the land was part of a bigger parcel that was then subdivided by way of now subdivision and survey, and this parcel gave new numbers. So what your obligation is at the first instance to ascertain the land is to, one, physically visit the parcel. After you physically visit, verify the records on a registry perspective. And there are two indices that you need to apply. The first one is the land registry, and the second one is the survey registry. Why is the survey registry important? Because the survey registry will give you the physical geolocation of that particular parcel. So when you're talking about ascertainment, you're told, Enoch tells me that where we are seated right now is 1120. Then the only way to verify what he's saying is to cross over to survey, buy the map of this particular, the registry index map for this particular space, and then trace where the 1151 is. Now, even myself as a lawyer, I do not have the capacity to geolocate it. By geolocate it, I mean to pinpoint the exact coordinates of this particular parcel. And that is where a registered survey comes in. A registered surveyor will now come and tell you that from the map, this is where the location of the land that you're buying. They will confirm and verify that this is the actual location. After that, they will then do what we call a survey, an area survey, to tell you that if the title reads 0.045 hectares, then on the ground it actually measures 0.045 hectares. So the question here is to tally 1, physical location, 2, tally the boundaries, and then 3, tally the acreage. Now that you're clear on, if this is the land I was shown, this is the land I am actually purchasing, and it is actually measuring the actual area that they had proposed on the title document. So that is the first phase of where you might go wrong if you were to skip that step.
And a lot of people don't want to spend money at that particular stage. I rarely hear of people actually wanting to invest in a surveyor before they've actually bought the piece of land. So I really see situations whereby a lot of people actually go through the whole process and they complete the process or partially complete the process. That means they have partly paid the money. And that's the point now they are saying, show me the beacon, or they call the lawyer, or no, not the lawyer, the surveyor, after the transaction has taken place, you know, which I think from what you're saying is actually a big risk.
Yes, it is an absolute risk because, again, the risk of ascertainment of parcel is, think about purchasing land like the way you purchase a second-hand vehicle. You will, some of us will go to an extent of even test driving it, getting a second opinion from a mechanic, and then eventually agreeing and haggling on the price based on our experiences and the information from the mechanic. So similarly, when you're told that a buyer has an obligation to beware, because you see, once you're already swindled, you've been swindled. You've already lost your financial interest in that particular space, and then the chances are high that you lose you lose the money, and you'll also lose the land. So one, I encourage communities to understand, people to understand that cheap is expensive is not just a phrase, it is true. And especially when you're being rushed into these processes, hata kuna mtu anaenda kulipa, take your time. It is not life. It is not life and death. A land purchase is not a heart surgery. So take your time. Let us verify everything prior to signing or issuing a deposit, because we are seeing a current model where people are being taken for site visits, and you're told, all of you want this land. In fact, the first 10 will only give a deposit, and you give a deposit even against no agreement for sale, even against no verification, even against no pre-process. And that is where you go wrong, because at the end of the day, you will still come back to the lawyer that you refused to pay, to now pay him a higher premium or a higher premium, to now recover and try and to trace your money back. So you'd rather waste time and lose the opportunity than lose both the opportunity and the money. There is never an urgency in this process, especially when you see there's a bit of a rush to conclude. Just understand that somewhere there's going to be a hurdle that you might not be able to break through. So ascertaining the property is mandatory prior to signing or paying of any deposit. Yes, to avoid that scenario where you've bought parcel A and on the ground it's actually parcel Z or parcel X. You have bought a parcel that says it is half an acre, and on the ground it's actually a quarter an acre. But you see, you've signed an agreement that you're buying this land. So in terms of enforceability, it's enforceable to the extent that the number is the same. But if the number is the same, you've agreed to sign, but in your mind you know you're buying half an acre, but you've not ascertained, then the buyer can easily avoid any form of liability if you yourself did not ascertain that the acreage is correct. And thirdly, ascertaining the beacons, that your neighbors have not encroached, and you also don't encroach, because that's also a possibility. You could be assuming the whole parcel covers your area, but you're also you're trespassing in someone else's land. Yes.
It's very interesting, because there's a time I had a transaction on land and I bought some land in Thika, and I insisted that they must put the beacons. Strangely enough, the broker told me, no problem, we're going to fix them tomorrow morning, or the following day, that is. And before I reached the site, the beacons were already put in place, and the surveyor had somehow vanished. And I took it, that is the correct beacon, only for me to finalize the transaction. And then I gave somebody that piece of land, and I told him, you can be farming, and in case there's any issue, you can always call me, this is my number. Just be taking care of my piece of land. A month down the road, guess what happens? The real owner of that piece of land comes, and then he's told by the caretaker there, no, this belongs to Francis, and this is his number. So the guy calls me and tells me, this is my land. I told him, no, but I even brought a surveyor. only for us to redo the whole thing and realize actually whoever came to put those was not actually a qualified surveyor, it was just a con job. My piece of property was actually near a swamp in the vicinity.
Absolutely.
In the vicinity. It was not very far, but it was in a swamp. So they didn't want to put the beacons in the swamp or near that swamp because they knew I would not buy. So they just actually checked for an area which was dry and very nice. And they put beacons there, and by the time I came, I was told the surveyor has already done the job. So I think this is also a case of actually you being physically present or working with a trusted person.
Absolutely.
Or a professional person.
Absolutely.
As opposed to trusting every other person, especially brokers who don't understand.
Absolutely. This is why you're told that you see, there's what the opinion they give, and then you have to get your own second opinion from your own trusted sources. So if in fact the minute you tell them you want to bring your own surveyor and they start bringing hurdles, cancel that transaction instantly, because it is you who is paying them. So there's nothing wrong for them giving you the documentation and then you verifying it yourself. So always understand that you're not operating, you're purchasing. It's an exchange of value. They're giving you land value, you're giving them financial value. So the exchange of value means that your balance of rights is the same. So use your own trusted advocate. And ideally, there's a phrase I read somewhere that a lawyer, a mechanic, and a doctor must be people you absolutely trust. So use your own trusted advocate. Let that person also navigate through the process of ascertainment because they understand what to look out for. And then that advocate can bring on board, or you can also bring on board, a certified licensed surveyor. Why do we use certified and licensed? Because you could be a surveyor by mode of training and graduation, but you are not a licensed surveyor. You've not been licensed, because you see, when a surveyor comes, for instance, if I give you a legal opinion as a lawyer, and my legal opinion is based on negligence, then of course I am liable for misinforming and misadvising you. Similarly, if you bring in a surveyor, they give you an errant survey report. At the end of the day, once you have all these documents, should an issue ever arise, like for yours, if you had used a licensed surveyor and that issue came up, then that surveyor would be liable to pay you for the loss and damages because you relied on their professional opinion to make that decision. And that decision has now put you in a space of loss and disadvantage. So the idea is always migrate from a point of your own information. Don't rely on what it's usually nice to trust everyone, but always verify. It is prudent to verify. Yeah.
There's some people who sell pieces of land using share certificates, and as opposed to title deed or certificate issued by the Ministry of Lands. What are the dangers of just a company issuing a share certificate?
Most of my client land selling companies will not like this response, but the Land Act is very clear on what pertains a document issuing and conferring a right over land. And it's either a certificate of title, a title deed, or a registered sublease or assignment. Why did I say sublease or assignment? Because the land regime recognizes several types of land. We recognize public land, we recognize communal land, and we recognize private land. So when it's talking about private land, the private land can also be held on either lease or freehold. So freehold principally means it's an absolute title. There is no term limit. Leasehold means that you have a term limit. So you'll get a certificate of lease, noting that that is your documentation. A freehold, you will get a title deed, right? A certificate of title noting that this is your land. Why did I start with that? Because it is important that communities understand that a share certificate does not necessarily confer a right in land. And this could be dependent on how you look at it. What happens is this. Most land selling companies will either one or two things. Buy a block parcel in an area that the titles have, the registry index maps have not been open for subdivision. So open for subdivision means maybe there was a restriction in this area as an agricultural land demanding that every parcel be not less than 5 acres. All right? So that land registry map cannot be subdivided unless that policy situation is altered or lifted. But now as a land buying company has bought that 5 acres and they intend to sell a gated community. So what they would do, if it is done right, they ought to register the land in the name of a company, for instance, that company should note in the formation that in the articles of association that each shareholder will be deemed to be owning a specific parcel of land to this acreage and size within the same. Now, it is their obligation to then register in the company collateral registry that this company holds this particular property, and this is the shared definition, this is the share interest.
Yeah.
Accordingly, then you have an obligation to then, as a company, when you issue that share certificate, also register that this person is now a registered shareholder, and this is the interest they hold in terms of size and acreage. However, that does not necessarily confer, because the name of the title is still in the name of the company, the mother title per se. So there is still an obligation for you to pursue subdivision. There is still an obligation for you to pursue conversion of that share certificate into title deed. In an ideal world, the safety of each shareholder is very clear. However, in a practical sense, the title is still at the ambit and use of the directorship of the company. In most cases, when you get a share certificate, you're just a shareholder. You've not been issued directorship. Whereas in practice, it ought to be one share also gives you a directorship stake, or you agree within the shareholder space who can then be a director. Because then the director's choice of how to utilize that title deed or that collateral that a company owns then also puts you at risk. And we have seen, even as late as yesterday, we saw sectional property purchase where the bank is now recovering units that had already been bought by purchasers. So the risk is very real for you to lose your asset based on the fact that you have a share certificate. So share certificates are an entry point, but they are not an absolute documentation securing your title and land interests.
Thank you very much.
I think we should
yes.
add to that. It's been a challenge these days, because when you go to purchase land, the people who are selling land tell us you can't get a title deed these days. You just get a share certificate. And you know, they just talk it casually, and then you just get to realize at the end of the day that you are not really having the rightful ownership of the land. So, I mean, we really need to, today I think you need to bring it to our understanding. Do I have to, if I have a share certificate, what else do I have to do, I'm a young person, to acquire the title deed? Because most of us, we are holding on to share certificates, and we think now that is all. Because the people who are selling land tell us, you can't get a title deed. It is only a share certificate. Maybe you can weigh in on that.
All right. I think just to tie that up quickly, we need to have clarity. When you're starting the process of purchasing land, the minute you hear that you'll have any form of challenge or impediment to getting a document of title is the point you involve an advocate. Because for me to tell you that I can be able to guide you in these 5 minutes to navigate through the process of moving from a share certificate to a title deed is highly unlikely. But what then an advocate would be able to do, number one, is to understand and secure the status of the mother title. That's the primary thing. Because if we know that the mother title is being held by so-and-so in this capacity, in what capacity is this? Because we have instances where, now let's assume we have 100 plots, that's 100 shares. We've already sold all these 100 shares, but none of these shareholders is a director. None of these shareholders actually has the title in their physical possession. So then that means the company is still registered under Enoch and Company Land Selling. Enoch is a director, he has the mother title. All of us have bought into it, and he's not yet willing to subdivide, or he doesn't, or well, in agreement is once we move in, we can then pull some resources and subdivide. But he's still able to legally, because he's still the sole director, the company is in his name, the title he holds it, he's still able to take that title and use it for other purposes like securing an interest, like a loan. He can even resell that parcel to someone else. Your shares will now, it's going to be subject of a litigation. We have to go to court now to prove that we got a share certificate and what have you. So transitioning from a share certificate to a title deed would require to bring in at least three professionals. You need someone who can support you with the company process, okay, within the company and lands registry, which the lawyer can then get maybe a company secretary and what have you. bring on board the actual directors who are now the directors on record of that particular title, then transition to subdivision through a registered surveyor, register that mutation, and then process the transfers, because the titles will still, all 100 titles will still come out in the name of the company, and then now the company can execute 100 transfers for each 100 individual shareholders. Yes.
Okay, thank you very much. Let's take a short break.
Okay.
Then we'll come back to that.
All right.
Dear viewer, we take a very short break, and please continue to like, share, and send your questions to the numbers provided. Thank you very much.
I wrote a book, a powerful book, that is 7 Keys to Success. All of us want to succeed. Nobody here wants to fail. I have no doubt you have a deep-seated desire how to succeed, but you wonder how. There are principles in this book. I call them keys. There are 7 of them that I have elaborated, that I have discussed in this book, and I have no doubt when you read this book, well, you will succeed. Many people have read it and they have come. The other day I met somebody who told me, well, I read your 7 keys to success and I have been teaching from that book. Actually, she's a pastor and she told me, well, I actually bought several, I have given to my leaders, to my people. You can use it also for teaching and even blessing other people in your family, church, and friends, even your place of work. 7 keys to success. I have no doubt when you read this book, you will succeed. Failure is not your place to be. You can be successful by reading 7 keys to success. Call that number, send a message, and we will respond to you and send you a copy of this book. God bless you and see you soon. Hello there, and praise be to our God. For the last 21 years, we have been rescuing abandoned babies all over this country. And by God's help, we have been able to rescue now close to 1,000 babies in this country. Well, we thank God for His enabling power. But again, I want to thank all our partners and friends of Happy Life Children's Home that have come alongside us to work with us, to help us to feed these children. Right now we have 61 babies, we have toddlers, we have some in school, we have some in primary school, in high school, school fees, vocational training, and it's not easy, but I want to ask, you can partner with us. You can help one of these children. You can be a monthly partner of any amount, whether you are a student, whether you are working, you are a parent, young people. I want to call upon each one of us. We can do something. Well, I always say nobody has everything, but everybody has something. And at Happy Life Children's Home, we have a saying, you may not change the whole world, but you can change the whole world for one child. We have a pay bill there. I want to ask you right now, please send help for these children. The pay bill is 75512. I repeat again, the pay bill number is 75512. That is 75512. That is the pay bill for Happy Life Children's Home account. You can indicate your name, and we will be more than glad to receive this help for the children, for the many, many abandoned children. Actually, our place is right now full. We cannot even take more. People are abandoning children everywhere. But I want to ask that you can work with us and also become a Happy Life friend, where you can become a monthly partner. If you want to do that, you can send a message or call that number or send a WhatsApp message, and we will be able to communicate with you and tell you how you can become a friend of Happy Life. God bless you. I invite you again, be a part of this journey. For the last 21 years, God has been faithful. You can be part of what God is doing through Happy Life Children's Home, Happy Life Mission, in educating these children and even supporting them with the food, milk, diapers, and everything that they need for their daily living. God bless you, and God bless you. The Bible says, as I close, well, he who gives to the poor lends to God. If you give to the poor, you are lending to God. And God is not a debtor of anyone. He will reward you. Thank you, and God bless you.
Dear viewer, thank you once again. We are back to your screens and back to your homes. In case you're watching us on Facebook, please like, share, comment. You can also send your questions to us using the numbers that which are provided. We are also live on Facebook. We are also live on Faith Today Television. And with me is Mr. Kiriba Kariuki, an advocate of the an advocate. Yeah. And we were discussing about the land issues. Yes. And Enoch had a question.
Surely. Thank you so much, Doctor. Thank you so much, Mr. Kariuki. I think where I come from in Uganda, I don't know if you heard the term, akatalekeka. You cannot, leave the show minus addressing it. Mm. So I am interested in learning, because today land has a lot of fracas. It has a lot of people, it has a lot of fear that people have built around that you can't just buy land in Kenya. It is not something secure or things like that. So today, when you try to dissect through real estate, you talked about a share certificate. That is where most of us were resting our confidence on having a share certificate, because that is what people were telling us, those who sell land, that we, even with the share certificate, you own land, you can even sell and things like that. But now you broadened it to us that having a share certificate is not enough. It is not all. The transaction is not complete until you have a title deed. Now that is where I want to really understand, because title deed is something that now for me I feel comfortable owning. Even if I have maybe 50 by 100 or whatever you may call it, having a title makes me feel like I have ownership of the land. So, Council, I want you to help us understand, is it easy to acquire a title deed? And how long does the process take? Yes.
I think there are two things that we have to fall back on this particular point. You see, a share certificate, by all intent and purpose, is a good document. Let me not cast darkness upon the whole sea of share certificates. It is a good document only if there is clarity on intention to eventually get you a certificate of title, a document of title. The procedures differ on a case-by-case basis. The time frames also differ on a case-by-case basis. Why this is important is because if, for instance, and we were having a very interesting discussion previously, if, for instance, the person who's issuing that share certificate is for all intent and purpose a good and faithful servant, who will eventually give you your share, your specific title, then the clarity then has to be simply, we have to resurvey the land. Okay, have clarity on that the boundaries that are there. The assumption is they usually survey it before, they just don't register the survey because it's usually also a colossal cost. So now once they fully sold, the idea is now they've raised the resources, they'll be able to register the survey, the mutation, the survey map and the mutation, and they'll be able to issue new title deeds in the name of the company first, and then eventually the company will transfer these title deeds to the individual purchasers. That is in an ideal situation.
Yes.
The inverse is also possible. It could be impossible to subdivide this land. Because of course I told you there's an instance where there's an pre-existing covenant, maybe a land control policy, maybe a pre-existing ordinance that prevents that land from being further subdivided. All right. Now the key things that you want to look at is what is the custody of the mother title. If you've been given a share certificate, the presumption is this is a company. So what is the directorship of that company? Do the shareholders have control of the directorship and possession of the mother title? Because there's an instance where now it's impossible. You have a share certificate and that is your nail in the coffin. That there is no, you're not going to get a title. So what is the status? What is the status and circumstance surrounding the mother title? Because also you don't want to be in a situation where you're being told, there's a mother title, we'll give you a share certificate, eventually you'll get a title, but you yourself, you've never seen that mother title. You've never verified the particulars of that mother title. You've never even gone as far, because now for us, I'll ask, where is the CR12 for this company? Who are the directors of this company that is registered in the mother title? All right, you have 2 or 3 directors. What is the interest of the shareholders and how is it being covered with this directorship proportionality? Because at the end of the day, don't for all intent and purpose, company law 101, a company is owned by the shareholders, not the directors. Directors are agents of the shareholders. And a composition of the shareholders principally means we can wake up in the morning and decide to fire a director as the shareholders. Provided you have the majority vote, you can wake up in the morning and determine to change, add, remove a director. Yes. So you have to have clarity on what is the status of that mother title and what is the possibility, if at all, of transitioning to a certificate of title.
Yes.
If that is true, then fine. But in an instance where one, as a purchaser of a share certificate, for all intent and purpose, you are not given access to a mother title that you've seen. You're just told it's there, but you've never seen it. You've not been able to verify that the parcel you occupy is actually the parcel on which the mother title sits. You've not been able to verify that those particular boundaries are within that mother title. Then that is a bad buy. Because there is no possibility.
You call it bad buy.
It's a bad buy.
A bad buy.
Okay. Yes. Good. It's a bad buy. You will have, and it's possible. You see, you've seen it in Kenya where you will enjoy the use of that land for a period of time. But eventually, you will be restored to factory settings. You have to go back. You have to go back to scratch because now maybe the owner, the actual real owner of the parcel, has now appeared. They want to take over. Maybe you are being sold government land, a road reserve, and the guys that you will get a mother title eventually. So the idea here is have a lot of clarity. And those spaces, I would advise you not to attempt to navigate them alone. Have a professional to support you in those kinds of transactions. Because even if it is possible and it is clear, it might not be necessarily easier for a person to understand the kind of documentation that will transition you from a share certificate to a title deed. Because even that share certificate you're being issued also requires a collateral registry search. You need to verify it, that this share is actually registered. It is in response to this particular parcel number. And this parcel number is registered as part of the collateral that this company owns. All right. So when they issue it to me, have they registered it with the Register of Companies to note that Enoch has bought parcel number 27. We have given him share certificate number 27 representing the parcel number 27. And this parcel number 27 measures this and this, and it is situated here and here. They have to file even that that mutation itself and show this 1, 2, 3, these are the numbers of units that we have, these are the parcels, and this is how each share certificate relates to each. Yeah. So the issue of share certificate also highly requires and demands a lot of goodwill on the part of the seller.
Okay.
So if the seller has ill will, then the probability and loss is immense, because they can even wake up one day as a director and resell that whole parcel to someone else. It is within their right. Yeah, if your interest is not registered as an indenture on the title, then the registry does not require to call you and ask you, oh Enoch, they're selling the whole parcel, are you consenting? Yeah, so that's another thing. The registry also needs to have your interest recorded within the mother title to note that, of this particular total 5 acres, Enoch and a few other people have interest in this particular acreage. So they cannot sell the total of it without getting consent from you. Yeah. And now for you to be able to navigate that space alone is a bit complex. So you might want to have an advocate. If you must go through that route of purchase, you might want to have an advocate to represent you in that particular process as a buyer.
Wonderful. We've covered a lot as far as the buyer, the person buying is concerned. Now let's change gears and come to the person selling land. How does a person selling land protect himself in a land transaction? And I'm saying this because I had a case whereby, and I'll just give that as one of the issues that arise from the buyers, from the seller side, whereby it was a lady actually who had a transaction with a certain gentleman, and somehow, I don't want to go to the whole story, she ended up not being paid. But the process went through, and she even transferred, and it was a very interesting story because she was actually taken to a bank and told, we're going to be giving this person a loan, and that loan will be used to settle your amount. And she went ahead, signed some papers. I don't know how this guy buying got these papers, took them to lands, and somehow transferred everything, and he kept quiet. After some weeks, the lady is asking for the money, and the guy says, I gave you cash. But he was actually saying that without paying. He hadn't paid anything. So it was a very interesting story because the guy was called in the police station by DCI. And he was asked, did you pay this lady the money? He said, yes, I paid her. What is she asking for? How did you pay? I paid her cash. She said she wants cash. And the story there is history because it becomes very, very difficult.
Absolutely.
Now, from a seller point of view, you're selling land. How do you protect yourself?
All right. I cannot overemphasize this. Not that all of you are not safe, but all of you are at risk. As a purchaser and as a seller, you are at risk. A seller can lose money. A seller can lose money and lose the land. Similarly, so a buyer can lose money and lose the land. So how do you protect yourself as a buyer? Number one, always stand by your warranties. Always stand by your warranties. Whatever it is that you're propelling as a product that you're selling has to be consistent to what you're saying that you're selling. Okay, so that you don't breach your own warranties. Because you see the laws of equity demand that if you come to equity, you come with clean hands. So if you come to complain to me that I didn't pay you, and then I also counterattack you and say you gave me a parcel that was not the right one when I did my verification, so that's why I refused to pay you, but I took the one that you gave me. So that means you are still at loss. So as a seller, you want to first safeguard yourself from contracting phase. So how do you protect yourself in the contracting phase? Number one, you have to understand that in an ideal situation, your contract will successfully go and you'll get paid in time. But also migrate from a point of a worst case scenario. So what if Bishop gives me the 10% of my 10 million, which is 1 million, I transfer my land and then he's unable to raise the 9 million. What is the contractual safeguard? So there's what we usually call clauses on reversion. So protecting your interest in saying that upon completion, you have an obligation to pay me within 21 days. If you don't pay me within 21 days, I can simply take that agreement and enforce against you for a reversion of the title. Of course, the registrar will not just give you the title back. You'll have to go to court. But you can put within that clause that reversion can be determined summarily. Summarily means you just make an application, attach the sale agreement, and the court will read the agreement and call Enoch. Enoch, have you paid the balance? You have not paid according to the contract section this and this. You are liable to return the deposit and all the costs that the seller incurred and return the title in the seller's name. All that can be contracted. And once you sign on that as a buyer, then you're bound by it. You can't wake up tomorrow and choose that now you've decided you will not pay the seller and you will get your money back. So you lose the deposit and you'll be liable to pay for the costs of returning the title in the name and any costs that the seller has already incurred, legal fees, maybe they've paid for consent and what have you. So that you protect yourself in the contractual phase. In the aspect of being paid a balance, a deposit and a balance model, because that is what we usually utilize. If you use an advocate, there's something called a professional undertaking to pay. So if I am representing the buyer, I will write to Enoch and tell him, if you give me the completion documents, and don't forget from the first instance you said the completion documents are the documents that will support the buyer now to transfer the title in his name. I will transfer the title in the name of the purchaser and issue, if you give me the completion documents, I give you a guarantee that I will pay you within 21 days of transferring. So within 21 days or 7 days, you can always negotiate so that if I get the title, I can search it, verify it, and then I pay you the balance. So the concept here is an advocate has given you an undertaking to pay. Why are undertakings important? Because professional undertakings are personally binding on advocates. So if I give you my undertaking, if I fail to pay, you can pursue me as an advocate, not the seller, not the buyer. Because then the advocate is bound by their undertaking to pay. So you can pursue me in case of any form of the breach of the contract. As the advocate, I'll be liable to pay you. Why is it important for the seller to have a lawyer? Because there are terms of the agreement that the buyer can introduce that might not be favorable to you. For instance, the example that Bishop has given, when you are insisting on a cash payout, as an example, there's something we call a schedule of payment. So the schedule of payment will now show that you have acknowledged, you must acknowledge, there has to be a form of acknowledgement that you have received these funds, because other than that, it's now your word against mine. All right? So you need an advocate to now be able to guide you that when you're receiving money in cash, please have a schedule where you countersign. So you say, you've given me 1 million in cash, I sign. You've received 1 million in cash, you sign. So that can be proof, conclusive proof that money was paid. Because now it is left to, did you pay? Yes, when did you pay? On this time and this time. Then it's a long and lengthy investigation that at the end of it, if the buyer is stronger, they might be able to swindle you. So a seller wants to be able to safeguard their interest by way of contracting and also having an advocate present to represent them. Yes.
Actually, my question would be, Doctor, did you involve a lawyer in that kind of scenario?
No, that was not my case. It was actually a story I was being told by one of the DCI officers when I had gone for my issue.
Sure.
They actually had a lawyer, but how the documents actually moved from the hands of the lawyer to the person who was purchasing and the transfer was done still remained a mystery. And how the title was changed to the name of the buyer, and yet the seller claims she has not been paid, became very mysterious.
Absolutely.
So as he's saying, it's very important for people to have written agreements, because the lady also happened not to have any written agreement from her side. So it was a word of her word against the man's word. The man insisted, I cannot get to the stage of getting a title deed without having paid you anything. And you insisted that I pay you cash, and I gave you cash. That's why you signed the documents.
Absolutely.
So it became very tricky.
Quite challenging.
So for the next few minutes, can you take us briefly through the area of inheritance of land? We have about 8 minutes or so.
All right.
Yeah, I know that we will not be able to do good justice to that, but we have cases whereby now the owner of the land dies, or let's not go to death. There is a will and there's the death. Take us through those two. I don't want that hand to depart somebody.
The principal aspect of this is, number one, you must have good title to pass good title.
Yes.
Okay? So Enoch, tafadhali make sure that all your share certificates become title deeds before you seek to give them to your children.
Very interesting. That is something I'm pursuing.
Yes, be very keen to ensure that you have your title. So you have good title, that's the only way you can pass good title. So when you talk about inheritance, unfortunately, Daktari, death has to come into this space because inheritance is principally succession. Now you're taking property of a deceased to direct beneficiaries. There are two aspects in this. You can have a tested death and an intestate death. A tested death is where there is a will that now dictates how the estate will be given out moving forward after the fact. An intestate death is where I have passed on, unfortunately, but I did not leave any mode of distribution for my estate. Now, what happens with a will? Number one, get an advocate who is licensed and registered to draw and seal and also read the will. So to draw means I will write it down for you. We will register it and seal it. We will seal it and then you will sign it. It will be witnessed. We will seal it once it's a registered document. Upon your demise, there is clear instruction on how to read the will. So the will be read, all right? And then there's still a further process of tested succession where we take the will to court and the court now enforces the will by way of an order saying that the one who is now the one who is now in charge of implementing the will can implement it in this particular specification. The will can be contested if you are not content. In most cases, if it is done right, very few to minimal changes can be made on the will. Doing it right means it was written by a qualified person, witnessed properly, registered, kept safe, like sealed, and then read in public or in the presence of the beneficiaries. And it's verifiable and trackable. Why is it verifiable and trackable? Because some people show up with wills that you can't tell where the source of the will was. So it is contestable in terms of verifiability. Now, intestacy. Intestacy means I have died and I have not had a will. Now, in Kenya, we have something we call the Law of Succession Act. The Law of Succession Act talks about a preferred mode of distribution. So if I did not write and say I want Enoch to get my house and my land, then the court will determine there is something called an order there's an order of preference in terms of beneficiary. So the court can say, if the family does not come up with a model of distribution in an agreement, then the court can say the rules of intestacy dictate that this is the order of preference in terms of, and then the court will vest. In most, that rarely happens unless there is a very protracted litigation on the succession. But in most cases, the family is usually given time. Go and argue even 15 years. When you're ready, come and give us a mode of distribution. We will then implement it. So there is that. Now, when it comes to the issue of inheriting land, clarity must be got. Start with good title to pass good title.
Good title.
Okay. So this title will now vest to a beneficiary. The question is how. If it was an intestate death, you have to file for letters of administration, file a model of distribution, and then get a confirmed grant for how to implement that transfer. Now here, of course, you cannot do that by yourself. You require an advocate who is also first a conveyancing advocate and also a succession practitioner, because not everyone can actually do this particular perspective. So there are two things that you need to have clarity on. Get good title, have clarity on who your beneficiaries are. And this conversation has gone very on and on. Who is a beneficiary? Now, a beneficiary can be your children, can be your spouse. Your spouse has a life interest. But a beneficiary is anybody who had a provable benefit from your life.
Male or female?
Gender notwithstanding. Because the Constitution tells us that we are one and the same. And since we are one and the same in the context of human rights, then we have equal rights and benefits as children. So number one, anyone who can prove a beneficiary then has a beneficial interest in the estate. All right. So this blows out of the water the conversation that boys must get a bigger share, girls must get a substandard share, and what have you. Girls should not inherit. That is neither here nor there. If you go through the judicial process, and even when you're negotiating, and not to throw a spanner into family conversation, but even when you're negotiating a mode of distribution, that should be at the back of your mind. That as a girl or as a lady, you are entitled to an equal interest to your brothers. So the conversation should be, if there is no mode of distribution that was preferred by the deceased, then there has to be an equal distribution of the estate. So land, have good title to pass good title, and then the succession process is mandatory. And there are people who come to us telling us there's someone who wants to sell to me some land, belong to their dad, they're selling at a throwaway price, but there's no succession. That's a red flag. So
about the beneficiaries, council karaoke, is it only in Africa where the beneficiaries are human beings? Because we see in the West where dogs are inherited
And cats.
How does that happen?
Yes, you can have inanimate objects and animals being beneficiaries to your estate. Now, what happens in the ideal scenario? Most people, in a bid to avoid, and I also encourage most of my clients, let's build an ease of transition, not by way of a will, but by way of a survivable trust. So what the trust will do is that it will hold all your assets. You will have an administrator of the trust, okay, a trustee in this particular instance, who then takes care of your affairs. And you see, a trust can survive you. You can, like right now, I can incorporate a trust to manage all my affairs, all my children, my bills, taxes. So a trust can survive you. And you can even make your beneficiaries trustees if you so elect. All right? Because in Kenya, we also have the ability to abuse that trustee relationship. So what would happen in that instance is, it happens that you can make provision for causes. You can wake up and say, my trust will now fund the Wangari Maathai Foundation to this extent every month or every year.
Okay.
All right? You can wake up and say, we have
Happy Life
the
Mission.
kennels. Yes, you can wake up and say, Happy Life Mission can receive this much benefit from my estate, provided it is existent. Right? We have the kennels in Karen, which is a rescue center for abandoned animals and injured animals. You can also wake up and say that is the same. In Kenya, we are yet to see that level of jurisprudence where someone leaves resources to a dog. But it happens in the Western world because there's also a level of elevation for of man's best friend and other pets that people would love to keep. But ideally, if you can be able to build a survivorship model, it would be better for you because you can be able to test it in life and also ensure that the system will be workable in death. So I encourage most of my, we, as Africans, we have a challenge with willing, and so it is better to go that route so that there are clear circumstances that you can set for beneficiaries to walk into their inheritance, and that also helps to put you in a better place to safeguard your interests even upon your demise.
That is wonderful. So we are running out of time, and from what I'm hearing, that it's good to have a will, but in case there's no will, you can actually go the other way, whereby you actually have a mode of distribution and all that. Time is far much gone, dear viewer. We were discussing, or have been discussing for the last 1 hour on land matters, buying, selling, and inheritance of land with Mr. Karaoke Kereba, an advocate of the High Court of Kenya, and Mr. Enoch. Let's have your parting shot, Enoch.
Well, thank you so much. I've really loved this discussion today. Very interesting. And as we are trying to discuss, I was remembering in the Bible what really happened, because as Mr. Karaoke was addressing matters land, he used the word parcel. He didn't use the word the land directly. He used the word parcel. So what came into my mind is that even in the Bible, Jacob, because he didn't do due diligence, he had to work hard. He was supposed to work for a woman. But because he didn't do the due diligence to find out, to confirm, is this the real wife? Is this the woman that I am working for? He ended up having to, work harder. And so, just to digress, but the entire concept is to do the due diligence. Council Karaoke has really made it plain for us that you can't just buy land anyhowly. I've learned today that just having a share certificate is not all. There's a process to pursue and complete. You can have a title deed. Today I am glad that I can have a title deed in Kenya, because when I came along, people are like, you can't have a title deed, you can't do this, you can't do that. But now from a lawyer's perspective, you can really have all this. And that is giving me so much confidence. Thank you so much, and God bless you.
And welcome.
Yes.
Thank you very much, Enoch.
Yes.
Welcome, Kereba. Your parting shots to the viewer.
I think to our viewers, I think it's just a word of encouragement. It is prudent to keep on investing. As Enoch has brought the Bible angle, where we are told to put our affairs in different issues. If you are a business person, invest in some land, there's longevity in land, there's longevity in real estate, and the aspect of a secured future is prudent. But always migrate from a point of information, understanding, and as I rightly put it, understanding can also be imported. If you are not very clear and cognizant of a process, always seek a third opinion, second and third opinion from a professional that you can trust or you can verify. And I wish you well in your land ownership journey, and also as you plan your successive plans as well. Thank you.
Thank you very much, Mr. Kariba, for honoring our invitation to come and speak to our viewers. And viewer, I just want to tell you that let's keep investing, don't fear. Let's be motivated by faith, not fear. Let's follow the process. Let's employ the professionals. They might cost you slightly much more, but they'll save you a lot. You can imagine if you have to go to court every other day because of a faulty deal or a fraudulent deal or whatever happened, and you have to go to court for the next 30 years, it's very, very expensive. Yet you could have actually followed the process, got a professional lawyer, a professional surveyor, verified everything and done things correctly. With that, I want to thank you very much for watching us, and may God bless you very much.